So I'm Shelley. I work with Michael and Laurie at Forge. My pronouns are they, them, theirs. And I wasn't asked to share what my favorite Supreme Court case is, but I would actually, I would roll back quite a bit to some really old cases, two of them. And the first one I would think about is Loving versus Virginia, which is a 1969 decision by the Supreme Court that finally got rid of miscegenation laws in the United States, which said that people of different races could not marry legally. And as we all know, that really was intended to prevent, for the most part, people of white and people of color, and particularly African Americans, from marrying. And so not only was that, the right thing and a very good thing for the court to do, albeit quite late, that's also a case that recognized a lot of the freedoms and the liberties that a lot of the later cases that are impactful for our community are built on. And so we owe a debt of gratitude to the Lovings, I think, for that case. And the other case that I think about is Fred Korematsu's case, which some of us may remember from civics courses. Fred Korematsu was under an internment order during World War II in California. He and his family were ordered to report to an internment camp, and he refused as a very young man to do that. He may have still been a teenager. And his case went all the way to the Supreme Court, and the Supreme Court made a really bad decision, and they upheld the constitutionality of the Japanese internment orders. And that was done for a few reasons, including the fact that the US government lied to the Supreme Court in that case. And so their decision was based on information that wasn't accurate. Many years, decades later, maybe 7 decades later, as a very, very elderly man, Fred Korematsu had attorneys from California who went back to the Supreme Court and essentially finally got his conviction for refusing to comply with the internment order overturned. And the reason I like that case and that I think about it is that, we're all human beings, and the people who sit on our Supreme Court are human beings. And for the most part, I think a lot of the time they're doing the best that they can. And they certainly make mistakes. And we've certainly seen them make decisions that I think a lot of us think were probably mistakes in the last couple of decades. But what I like about that story is that through the persistence of activists and Asian American activists and lawyers in particular, Fred's conviction was overturned, and the court in some ways righted the wrong that it had done many years earlier. And so I sort of like that there's a kind of a redemption story there for all of us. So those are my favorite Supreme Court cases. Thank you for indulging me. Yeah, and Heather just mentioned in the chat box the Dred Scott case, and there are any number of other cases that the Supreme Court made some pretty terrifically horrible decisions in. And sometimes we're able to come back and correct that later. So I'm actually really excited. I'm happy that you're all here today. And we're here to talk about the Bostock decision from the US Supreme Court that came out a couple of weeks ago. Many of us, I'm sure, know that the Bostock decision is actually a decision that was issued in 3 cases, all smashed together. So those are called consolidated cases. So the court took 2 cases that were brought by plaintiffs who identified as gay, and they took a case by a plaintiff who identifies as trans, and they mashed them together because the issues were very similar, and they heard arguments together on them, and we talked about that in person many months ago at the community center in Milwaukee after those arguments happened. And they issued one decision that applies to all of those cases and answered the questions in all of those cases. So what we'd like to do today is just kind of review the cases, the three cases, where those cases came from, who the plaintiffs were to some degree, and what the decision says, what it says about discrimination in employment, and then what the case might mean for other areas of law and other areas of our lives. So I am going to share my screen, as Michael said, just to put a little bit of information up visually. And as I go to share my screen, it'll be quite challenging for me to see any of you or to see the chat box. So if anyone needs to get my attention, perhaps Michael can do that for us. So give me 1 second here while I try to share my screen. Okay. So I'm going to hope and assume that we're all looking at a screen, a PowerPoint presentation that says 3 Supreme Court cases at the top. So these are the 3 cases that the court heard and issued a decision in recently. The 3 cases were, number 1 on our list here is Harris Funeral Homes versus EEOC, and that was a case brought by a trans woman named Aimee Stevens. The second case is Bostock versus Clayton County. I believe that's Gerald Bostock, who brought that case. He was a gay man who believed that he was fired for being gay. And the third case was Altitude Express versus Zarda. And I'm afraid that I'm not entirely sure of Mr. Zarda's first name. I believe it's Donald. And he also believed that he was fired from his job for being gay. So all 3 of these individuals at some point many years ago, had something happen to them at work and decided ultimately that the way they needed to deal with it was to file a lawsuit and to file a lawsuit against their employer. In the case of Aimee Stevens, the Equal Employment Opportunity Commission actually filed a lawsuit on her behalf. That is something that agency is allowed to do. It doesn't do that so often these days, and it probably did that while President Obama was in office. And because the EEOC filed that lawsuit, that preempts Aimee's ability to do that for herself. So, so her case was brought by the EEOC, but she was there every step of the way with that case. And I'd like to just talk about Aimee a bit, since we are here today to talk about what the effect of these cases are on trans and non-binary people in our lives. And a lot of times it's hard to remember sometimes that these legal cases and these precedents we talk about are really a product of people's lives and people's experiences. And sometimes I think it's nice just to know who the faces are behind the cases. So, we live in a world where we've got access to a lot of information these days, and we may have seen photos of Aimee or read about her story, but this is Aimee and Aimee's partner, and a couple photos of her. So a little bit about Aimee and her case in particular, because I think we'll talk about her case in particular as we talk about the Supreme Court decisions. Aimee was a funeral director at Harris Funeral Homes and had been a funeral director there for 6 years. Aimee had excellent work evaluations. By all accounts, she was a great employee. She was well liked by people in the community and by customers. Aimee was assigned male at birth, and until 2013 was presenting as male and identified as male at work. In 2013, she wrote a letter to her employer telling her employer that and disclosing her gender identity, and telling her employer that she was going to start presenting as a woman, and that she intended to present as a woman at work at the funeral home. The funeral home, which I believe was owned by a couple of brothers, the brothers did not have a positive reaction to Aimee's disclosure, as we can imagine, given that her case ended up in front of the Supreme Court. And they fired Aimee. And they pretty explicitly fired Aimee because of the fact that she is transgender, and that she stated that she wished to appear as female in her authentic gender at work. And they said that, really, and said it in writing. And so Aimee's case, in Aimee's case, it was quite clear that the reason she had been fired was because of her gender identity. So the issue that Aimee's case presented to courts all along the way, and the issue that the Supreme Court answered in the Bostock decision, is whether the word sex in Title VII, which is our federal employment non-discrimination law, whether the word sex in our non-discrimination law should be defined to include or should also mean gender identity. The issues in the Bostock and the Zarda cases, or the Altitude Express case, were very similar, and this is why the court consolidated the cases for efficiency. But the issue in that case was very similar, and the issue is whether sexual orientation should be included in the definition of sex in Title VII. So these two issues were a little bit different. This case was different from Aimee's in that it was focused on sexual orientation, and in that the two plaintiffs were fired from their jobs, they believe, for being gay. Some of the lawyers on the case I wanted to stop and talk about for a quick minute too. Some of us may know Chase Strangio, who works for the ACLU. Chase is a member of the trans community. Chase has been working at the ACLU for several years. And the ACLU specifically represented at Aimee Stevens in particular in these three cases. And the ACLU was involved in her case for a very long time. And so Chase had a very public role in being out and talking about the case, being a face in many ways for the case and for the trans community and for these issues. And Chase had a lot to do with the underlying strategy and how the case was presented, in how the cases were presented at the Supreme Court. And, you know, I want to just take a moment and acknowledge that, you know, Chase is a great champion for our community. And just like Chase, there are many trans lawyers who are doing this kind of work every day in the country, and who are doing other kinds of lawyering too. So sitting at desks and representing corporations, or writing wills for family members. Trans lawyers are everywhere in this country, and if you have any interest in learning more about trans lawyers, there's an organization called the National Transgender Bar Association that I recommend that you check out. A couple other lawyers on the case are slightly more seasoned lawyers, and it is not unusual for a more experienced lawyer and a lawyer who particularly has experience arguing at the Supreme Court to come onto a case when a case reaches the Supreme Court and and to bring their expertise in Supreme Court litigation to the case. And so the lawyers who actually argued these cases, one was David Cole from the ACLU. He has been at the ACLU for a very long time and has done many, many cases involving LGBTQ plus issues. Pam Carlin is a law professor at Stanford. She's widely considered to be a constitutional law expert in the country, is quite well respected, has a lot of experience arguing at the Supreme Court, runs a clinic at Stanford, actually, where law students who hope to someday become appellate lawyers and Supreme Court advocates work in that law clinic, and they will produce briefs and they will represent people actually from the law clinic at Stanford. I'll just stop for a quick second and say that, you know, David and Pam obviously helped achieve a victory on behalf of our communities. And as we talk later, you know, it might be interesting to talk about, as Lance mentioned earlier, some of the things that happened during the case and during the argument in the Supreme Court. You know, Lance said that he heard a lot of the justices on the Supreme Court asking questions that, you know, made him really unsure how the court was going to decide the case. And I think that's a really generous and kind description of a lot of the questions that the court was asking. It may have seemed from the questions they were asking that they had no idea what they were hearing, that they did not know anything about transgender people in particular, or about gender identity. And, you know, some folks were very critical of David and Pam in some of the ways that they handled those questions, in some of the terminology and some of the words they used, talking about their clients, talking about us as a community, and in some of the arguments they made and the way they framed those arguments and presented them to the court. And so I think it's very interesting to see that we had, in particular, you know, not somebody from our community arguing Aimee's case, and you know, and to talk about what that might mean. So, Aimee's case, the Stevens case. Aimee made three arguments in her case, and then we'll talk about the decision in Bostock and what it means. But Aimee made three arguments in her case, and this case, of course, I think most of us probably have heard, was about the definition of sex in our non-discrimination statutes. We have a federal non-discrimination law that applies in employment contexts, that prohibits discrimination on a number of bases, and we'll look at the language in just a second. And one of the reasons it prohibits discrimination is because of sex. And you know, for many, many, many years, the question for trans advocates has been, how do we get courts to understand that, you know, they really need to think about gender identity as falling under this legal definition of sex discrimination, so that when a transgender person experiences discrimination, we can say, hey, you know what, we have statutes that say that you don't treat people differently based on their sex, and that's been interpreted to mean lots of things, including gender, and so that has to also mean gender identity, and we need you to explicitly say that if we're not going to change the laws itself. If Congress isn't going to change the laws, we need the courts to interpret these laws more broadly to ensure that we get to go to work, that we get to find housing, that we get to go to school, and we get to do that without discrimination. So Aimee and her lawyers made a couple of different arguments to the court, and, you know, ultimately, I don't want to say something that I'm going to regret later if you all ask me questions about it, but ultimately I think the decision in this case didn't really hinge on any of the distinctions between these arguments. I think the court answered a kind of a much broader question. But Aimee presented her case in 3 ways and tried to give the court 3 ways to think about how to bring gender identity within the definition of sex. So the first thing she said is, I am a woman. And it is illegal, it is sex discrimination for my employer to treat me differently just because I was assigned male at birth. So I am a woman who is being treated differently from other women because I was assigned male at birth. And therefore, when I am fired because of my gender identity or because I am transgender, I am being fired because of my sex. So that was the first way they presented her argument. The second way they presented it was to say, and this is one of the arguments that David Cole made that some people had some discomfort with. But this argument went essentially, okay, if you're not going to recognize that I am a woman, then for this legal argument, you are saying that I am a man because we only recognize 2 sexes or genders legally. So even if you are going to conceive of me as a man, it is illegal for my employer to treat me differently from other men and to fire me simply because I don't conform to what my employer's stereotypical ideas of what a man is supposed to look like. Okay? So I am a man who is presenting as a woman, is how this argument goes. And for that reason, if that's the premise you're going to use, that is also sex discrimination. And the third argument they made is, let's put aside trying to categorize Aimee's sex or gender, and let's just say that the fact that Aimee was going to transition, perhaps medically, we don't know, but certainly she wanted to change how she was presenting in the workplace. And again, we can sort of quibble about some of the language in this argument, but the way that argument got presented was, look, you don't have to decide what my gender is. You don't have to decide whether you think I'm a man or a woman. You don't have to decide what the essence of sex is or what the essence of gender is. All you need to know is that I wanted to change how I was presenting my gender in the workplace, and I got fired for that. And how can that not inherently be discrimination because of gender or because of my sex? So those are the 3 arguments that they gave the court to deal with. And, the court, as I said, I think brought back a decision that is a little broader even than those arguments that Aimee and her lawyers made, which I think is a great thing. And so why is Aimee's case important, right? Aimee's case is important because it really was the culmination of about 20 years of advocacy on behalf of trans people, non-binary people, gender non-conforming people. And it was a lot of work that was done by trans lawyers, pioneering lawyers at places like the National Center for Lesbian Rights, Transgender Law Center, Lambda Legal. Lots of these places that have been around for many years, they made a really concerted effort starting about 20 years ago to really press this issue in the courts that, hey, you know what? We don't need Congress and we don't need state legislatures to change laws. We don't need them to think that, they're doing some big controversial thing by increasing protections for trans people. All we need is for the court to recognize that this is stuff that really is already prohibited by the text and by the spirit of our non-discrimination laws. So we started bringing these cases maybe 30 years ago, and for the first 10 years or so, we got some really bad decisions where courts said, look, we don't understand what this is. We don't know what gender identity is. Frankly, we don't understand trans people. And, we just don't see how any of this is prohibited by our existing laws. So, no, there are no protections for you all under existing sex discrimination laws. Trans lawyers came back with a really interesting argument and pushed these cases then for the last couple of decades. And I am not going to say I told you so, but I will say that I was a person who thought that I really wanted to believe that the court was not going to undo these 20 years of expectations that we have now developed, that we have legal protections under the definition of sex discrimination. I really wanted to hope and believe that the court was going to honor the fact that all of us out in the public had these expectations that had been built up, for almost 20 years, and that they weren't going to essentially, for most of us, take those protections away. So for instance, we in Wisconsin live in the Seventh Circuit, and that just means that's an intermediate court. It's the step below the Supreme Court, and the Seventh Circuit has said for many years now that transgender folks have protection from employment discrimination. If the court had decided this case in a different way, they might have actually been lessening protections for those of us who live in Wisconsin. And that is true of many, many states because of what federal courts have been doing for the last several decades. So the court really, I think, took the next logical step in the argument that trans lawyers have been making, and we'll look at that, I think, in the next slide. The other reason these cases are important, and Aimee's case is important really in particular, is that not all states have statutes that protect people from employment discrimination based on gender identity. Wisconsin is, in fact, one of those states. So we have a state statute that does not include protections for gender identity. Now, we'll talk about how that gets interpreted, and it does get interpreted to include gender identity. That's a little preview for you. So we do have protections in Wisconsin, but part of the problem is this is just really hard and confusing to figure out. It's hard to understand what the parameter of our rights are because they're not clearly set forth in our laws that are on the books. So not all states have protections, and not all states' courts are interpreting their sex discrimination statutes to include transgender people. And so Aimee's case and the Bostock decision is going to fill in some gaps and is going to create some new protections for lots of people in lots of other states. Other reasons Aimee's case is important. Aimee's case is important because, and this is what I think we'll really get to talk about once I turn off my screen and we get a chance to converse. Aimee's case is likely going to be the first in a series of dominoes that will affect how other federal laws get interpreted. So laws that apply in schools, like Title IX, laws that apply to housing discrimination, all across the board. This case is going to have ramifications that I don't think I can even adequately describe here today. And I think that many of us know that and sense that. And I think that's what the interesting sort of conversation about this case is how do we now use this case to continue to advance protections in other areas of law and in other really important aspects of our lives. And again, the cases are important because they also set that kind of example, and they'll have that kind of effect on state courts, like courts in Wisconsin, who are interpreting non-discrimination statutes that don't explicitly include gender identity. I'm just going to give you a little food for thought here and take a little break before I talk specifically about the decision. And give you a few statistics about employment discrimination and ask you to kind of think to yourself whether you think these are true or false. So the first is that 30% of trans and non-binary employees experience discrimination at work. 30%, a third of the population almost. Do we think that's true or false? That is true. So a third of people who identify as trans and non-binary believe that they've experienced discrimination at work because of their gender identity. That is a lot of people, a lot of us who need protections from employment discrimination. The next one, 5% of trans or non-binary employees experience harassment at work. Experience harassment at work because of their gender identity, 5%. True or false? Yeah, that number is actually false. That number is low. And the reality is that 15% of trans and non-binary employees report experiencing harassment at work. One final question. Almost half, so almost 50% of non-binary people let others assume their gender when they're at work. And that's true. 44% of non-binary people who answered a survey said that they don't even try to explain their gender identity to people at work because there is such limited understanding of non-binary identities, and that they instead go to work every day and just allow their coworkers to assume what their gender is, or to assume what their pronouns are, because it is often too challenging to explain that to the people that we work with every day. So, you know, there are a lot of places, as we know, and as many of us know from our own personal experiences, where we need some additional protections in workplaces and other places as well. So here we are. This is the text of Title VII, which is our employment non-discrimination law federally. This is the text, this is the law that the Supreme Court was asked to interpret in Aimee's case, and in the Bostock and in the Zarda case. All three of them were asking the court to find that sexual orientation and gender identity fit within this non-discrimination law. And so what the law says, with some things cut out to make it a little easier to read, what the law says is it is unlawful for an employer to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. So the phrase there that's really key is because of such individuals' race, color, religion, sex, or national origin. That is the text of Title VII. That is what that text looks like when it was enacted in 1964. And my guess is that most of us on this call will be long gone from the face of the earth before this text is ever amended to include more language, more protected characteristics than that. This law is probably not going to change, and that is the reason that trans lawyers and advocates have really been going to the courts and saying, hey, we need you to find that we're protected by these existing laws because we think they aren't going to change. Now, as I talked about earlier, trans lawyers have argued for the past 20 years that we are protected by sex discrimination statutes. And this case that I think Michael mentioned earlier, Price Waterhouse versus Hopkins from the 1980s. This is a case that really gave us the ammunition and the arguments that we needed to bring these cases and to get courts to find protections for us. Ann Hopkins was a woman who worked at Price Waterhouse. She was up for partnership, and she was denied partnership by her male partners, who all, for the most part, gave her really negative evaluations. And the evaluations, it was very clear, were not based on Ann's abilities or Ann's work performance, but instead were based on Ann's appearance, Anne's personality, and what her male partners saw as Anne's lack of what they thought was appropriate femininity. And so this is a quote from that case that I'd like to read. So Anne Hopkins was told that she needed to walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. Her male partners called her macho. They said that she overcompensated for being a woman and that she needed to go to charm school. So these are all things that Anne's male partners said about her and prevented her from attaining partnership in the firm because of. And Anne's case ended up going to the Supreme Court. And the Supreme Court said, you know what? Those are a whole bunch of disgusting stereotypes that we have allowed to be perpetuated in our society about people that we think are women and how they should appear and present and act. And if we have a law that says that treating people differently because of their sex or gender is not okay, then it is also not okay to treat people differently just based on these really antiquated notions that we have about gender. And so this became called a sex stereotyping theory of sex discrimination. And that sex stereotyping theory is really what lawyers have been pushing for trans folks for the last 20 years. So we get to the Bostock decision. After all these years of hearing sex stereotyping cases and finding that anybody could bring a sex stereotyping case, including trans people, and that trans people could find protection from discrimination by using that sex stereotyping theory, we then get in front of the Bostock court. We get in front of the Supreme Court with these cases, and what we asked them to do was to say more than, you know, trans people just can't be subjected to sex stereotyping. What the court was asked to do was to find that being transgender, all right, that one's gender identity is a protected characteristic under Title VII, under our employment non-discrimination laws. And so what the court did was it essentially said, you know what? Yes, we agree with that. We believe that Title VII's prohibition on sex discrimination prohibits discrimination against people who identify as gay and people who identify as transgender. And so there it is. That is the definitive statement that sex discrimination includes discrimination for being gay or for being transgender. The court said this a few different ways and gave a few different explanations of it. And so I'll show us this second quote from the court, from the Bostock decision. So the court said, because discrimination on the basis of homosexuality or transgender status requires an employer to intentionally treat individual employees differently because of their sex, an employer who intentionally penalizes an employee for being homosexual or transgender also violates Title VII. Okay, so that's a much broader statement by the court than if the court had just extended the Price Waterhouse ruling and said, you know what, if you're relying on stereotypes, old tired stereotypes about men and women, then you're discriminating against people based on sex. The court just straight up said, all right, being gay, being transgender, you are protected from discrimination under Title VII, period. So this is a pretty strong statement by the court. Now, there are some interesting aspects to that case and to that decision and to those two quotes we just looked at. One, I think that's probably obvious to a lot of us is that the court uses words like gay and homosexual and transgender status instead of using words like sexual orientation or gender identity. And so what does that mean? You know, the way most non-discrimination statutes work is that, we are not protected because we have any particular characteristic, so that say that we identify with any particular race. So it is not, people of color alone who are protected from discrimination by our non-discrimination statutes. It's everybody is protected from being discriminated against, no matter what their race is. A person's race, no matter what it is, should not be the basis for a decision that's made about them at work. Well, we treat sex the same way. 30 years ago, when the courts were interpreting sex, they didn't say, these laws are intended to protect women. And so women are protected from sex discrimination, but men are not. No, that's not how it works. The idea is everybody is protected from having decisions made about them because of a personal characteristic. In this case, their sex or their gender. So what does it mean that the court didn't talk about sexual orientation or gender identity, but instead kind of called out some specific identities and orientations? Is that important? People have different opinions about this. People are thinking about these cases. Experts are talking about these cases and talking about what they think that means that the court used that language. My opinion, and I think the weight of expert opinion, is that what we're going to find and what we're going to see in the future as these cases get applied is that we're going to have a broader application of the principle in these cases, so that they are not, in fact, going to be used. And I think maybe the court didn't intend this either, but that they're not going to be used only to protect somebody who identifies as gay or as transgender, so that really what we have is protection for discrimination based on these characteristics that those identities are representing. So sexual orientation or gender identity. So when I talk about these cases, that's the interpretation of these cases that I think is most appropriate, and that most legal experts think is appropriate, and that I think is appropriate for us to rely on. We're going to learn a lot as time goes on and as these cases get applied, and we're going to see what the parameters are of these cases. What we can take away from Bostock and take away from all of the other decisions from the court then is that sex in the context of Title VII is really being interpreted to mean a whole lot of things. Sex or gender, gender identity, gender expression or presentation, sexual orientation, and sex previously had been defined to include pregnancy as well. Now, the Bostock case was also about 3 people who got fired from their jobs. And the decision says, if an employer fires somebody for being gay or transgender, they're violating Title VII. Well, again, I think it's quite reasonable to think that this decision applies to all aspects and all possible kinds of workplace discrimination. What courts are supposed to do is they're supposed to look at the facts of a case before them, and they're supposed to answer questions presented by those cases based on those facts. What the court had in front of it was 3 people who lost their jobs, 2 who identified as gay and 1 who identified as transgender. And so I think that's why we have a decision from the court that says it's illegal to fire somebody for being gay or being transgender. But again, it is quite reasonable to interpret that the reasoning and the logic of the case means that all kinds of discrimination are prohibited, not just being fired. And that also means that workplace harassment, which is a kind of discrimination, is also incorporated in and covered by the language of the Bostock decision. So that, again, when the court is only talking about firing, about people losing their jobs, what they're really doing is basing that on an interpretation of Title VII that is going to mean that all kinds of discrimination are outlawed based on gender identity and sexual orientation, and that includes workplace harassment, which some of you know we've talked about before. And workplace harassment is a kind of discrimination that has a little bit different flavor. So it's unlike discrimination that often kind of directly affects our paychecks, and it's instead about the environment that we work in. And so when we work in an environment that's hostile and is abusive for a reason that's illegal, like sex, or as we now know, sexual orientation or gender identity, that's not okay and that's unlawful, because that also affects the terms and conditions of our employment. That ultimately is going to affect our paychecks. We are not required to work in jobs where we are being treated abusively. And I'd just like to reinforce that as we think about these cases, as we think about gender identity discrimination in particular, these are principles that apply to discrimination, that come from many years of Supreme Court cases about discrimination. So it doesn't matter, again, what our gender or what our gender identity is. We can all be impacted by sex discrimination or sex harassment. The perpetrator, the person who's doing the discriminating or the harassing, it doesn't matter what their gender is. It doesn't matter what the gender of somebody who's being targeted for discrimination or harassment is. And so, I want to reinforce that particularly means that there is protection for people who identify as non-binary, right? And the other thing we get protection from is people's mistaken beliefs about our identities. If somebody doesn't identify as trans, but they're getting harassed at work because a coworker thinks they're trans, that's still illegal, right? And that only makes sense. I mean, it's not okay. These are behaviors that we don't approve of and we don't want happening in workplaces. And so it isn't going to be a defense for discrimination or harassment to say, oops, hey, you know what? It turns out that person actually isn't trans. And so the fact that I was harassing them for being trans is like okie dokie. No, mistaken beliefs or perceptions about people's identities aren't a defense to discriminating against them. And again, just some more general principles for all of us to bear in mind. Harassment and discrimination can come from lots of different places in a workplace. And for the most part, whatever the source of the harassment and the discrimination is, it's going to be considered illegal under Supreme Court precedents. So we often think about our boss as being the person who might discriminate against us, treat us differently, or harass us. Coworkers can also harass us. Employees who are supervised by us can engage in harassment that's illegal. Same with interns, board of directors members, and clients and customers. So anybody where your employer ostensibly can exercise some control over that person in the workplace, they are required not to be engaging in harassment, and you should have a remedy by going to your employer and complaining if that's happening to you. I want to just show a couple slides of some things that can happen to us in the workplace that are not the kind of discrimination that just immediately affects our paychecks, but that are more along the lines of harassing and abusive behaviors, and behaviors that, certainly if they happen repeatedly, they are going to be considered illegal by courts. So, the prime example of that is using somebody's wrong name and their wrong pronoun. whenever that happens, it is not right, it is hurtful, it is harmful, it shouldn't happen. If it happens once or twice in a workplace, if it happens inadvertently, a court may say, you know what, I don't think that that was hostile or abusive, and so we're not going to call that workplace harassment. It's still wrong, right? But if it's happening repeatedly, and it's not happening inadvertently, these are things that courts look at and say, hey, you know what, that's not okay. You're now creating an environment that's abusive for this person by repeatedly using the wrong name or pronoun or failing to respect somebody's identity, by refusing to allow somebody access to an appropriate restroom. And as a part of that, by forcing somebody to use a single stall restroom or a restroom that's in an inconvenient location, forcing people to adhere to dress codes or grooming standards that are not right for their gender identity. Certainly, name calling, jokes, pranks, offensive comments, images, refusing to work with somebody or shunning them, um, ogling somebody, staring at people, following them around, disrupting them at work. Those kinds of behaviors, when they are happening repeatedly in a workplace, certainly can constitute harassment and are going to constitute sex harassment. Another principle that we can take from the court's cases, and a principle that we can now take really clearly from the Bostock decision, is that employers have a duty to prevent and eliminate discrimination and harassment in their workplaces. And through a series of court cases, they've been told that they have a particular duty to prevent and eliminate sex harassment. And there's some kind of key things they have to do in order to show that they're taking steps to prevent and eliminate discrimination and harassment in the workplace. And one of them is offering, regular trainings about what sex harassment is, how to prevent it, and what they're going to do if it happens in their workplace. Well, it's pretty clear from the Bostock decision that now means that employers really need to be including gender identity and sexual orientation in their sex harassment trainings if they're not already doing that. And on top of just training people about this, they need to have effective procedures in place to receive complaints and to investigate complaints if discrimination and harassment happen at work on the basis of gender identity and sexual orientation. Now, what employers does the Bostock decision apply to? Okay, it doesn't apply to all employees. And as we talk about what we can do with this decision after we finish here in a second, we'll talk about some gaps in the law and how they get filled in. But one of the things we need to know is that Title VII applies when an employer has 15 or more employees. So that means that small employers with less than 15 employees are not subject to the Bostock decision, and that employees in those workplaces need to rely on the kinds of arguments we were making prior to Bostock in order to find protection from discrimination. The Bostock decision and Title VII apply to a range of employers. There are few that are accepted, and those are essentially government employers. So Bostock applies to all private employers. It applies to temp agencies, job agencies. It applies to unions and union membership. It applies to the federal government when the federal government is somebody's employer. And it mostly applies to state and local governments when they're acting as an employer, with a few exceptions. So what are some ways we can possibly fill in some of the gaps that are left by Bostock in the employment discrimination context? Well, One way is, the arguments we made before Bostock. Another way is the Equality Act that has been pending in Congress and, probably is not going to be passed by this Congress. And while the Senate is constituted the way that it is, we probably need some political change before the Equality Act could be passed. But our Senator Tammy Baldwin from Wisconsin is a big advocate and a sponsor of the Equality Act. And what it would do is it would, in fact, rewrite all of the laws on the books across the board to add gender identity and sexual orientation to them so that we just wouldn't have any more questions about what these laws mean. And as we said earlier, the state of Wisconsin, so if we're in Wisconsin, there is some gap filling coverage for us. If we work for an employer who has less than 15 employees and Title VII and Bostock don't apply, there is some state law that fills in some of those gaps. We have a state law that prohibits discrimination based on a number of categories, and it includes sex and sexual orientation. It doesn't specifically say gender identity, but as point number 2 on this slide says, the statute is interpreted to prevent gender identity discrimination by our courts. This applies in employment, it applies in housing, and it applies when we're out in places that are open to the public, like stores, restaurants, gyms. And as I always like to remind people, Wisconsin was the first state in the country to prohibit sexual orientation discrimination in 1982. And what we need to do is get gender identity added to the statute so that we have the same kind of clarity with state law that we're starting to achieve on the federal level. For those of us who are in Milwaukee, Madison, a few other cities in the state of Wisconsin, these municipalities also have laws protecting us from gender identity and sexual orientation discrimination. Milwaukee does for sure, Madison does for sure. And they apply, again, in employment, housing, and places of public accommodation. We can't yet make complaints in Milwaukee and have them investigated, but we're working with the city of Milwaukee and they're working on getting these complaint procedures in place so that we'll have some recourse at a local level for gender identity discrimination as well. So I'm going to stop sharing my screen and say that that's all I have for you all right now. And hopefully we can open this up to about 20 minutes of conversation about the things that I just talked about and about any questions or comments that you all have.
And hi, this is Michael. I just wanted to encourage folks, if you'd like to jump back on your video, we'd welcome to have this as a more open conversation and dialogue. And as folks are thinking about their questions and potentially coming back on video, we do have one question already, which is, what if, oops, hang on, sorry, what if religion is used as an excuse to discriminate?
Yeah, that's a really, really, really great question. And I'm going to try to give a really brief answer to that, which means that I'm probably not going to be able to answer the question fully. That question, the answer to that question depends on a lot of things, including the context that we're talking about. I'll stick with employment law because that's what we're talking about right now. There are some contexts in which employers can discriminate based on religion. That ability is really reserved only for religious entities who are employers. And that really generally means like a church itself or a synagogue, the religious institution itself. It also often extends to schools. So a religious school can say, we're going to discriminate against people who don't comport with the tenets of our religion. And that often can be acceptable. Now, in other workplaces, in more common employment settings, in public and private employers, Another person's religion, your coworker's religion or your employer's religion, is not a valid basis. That is not a justification for discriminating against somebody for any reason, including sex and including sexual orientation or gender identity.
So Shelley, one of the things that I didn't hear you mention was when this goes into effect.
Mm. Yeah, that's a really great question. The kind of cool thing about court decisions is that, you know, unlike Congress or a state legislature who passes a law and it goes into effect maybe at the beginning of the next year or something like that, a court decision becomes effective essentially immediately. So that means that these rights that the Supreme Court affirmed that we have, you know, in some ways were already available to us, assuming courts were interpreting these laws in the right way. But the Supreme Court has affirmed that they are absolutely there, and that is effective as of the day those opinions came out.
That's excellent. So folks can certainly share your questions in the chat, or feel free to ask verbally or on video, however you feel comfortable doing so. And I want to definitely give space for folks to do that. Otherwise, I have a couple of other questions if other folks do not.
Yeah, and you know, Michael, if you don't mind, you know, one thing I'd really like us to talk about, even if just for a couple of minutes, is, you know, the other thing that happened right around the same time as the Bostock decision, which is access to healthcare and discrimination in healthcare settings. And I see Kevin has just asked that question in the chat box. And, you know, I've talked to many people over the last couple of weeks about what do these two things mean? So for those of us who don't know, just a couple of days before the Bostock opinion came out, our current presidential administration rescinded something called a regulation. And that regulation, in kind of lay person's terms, is really just an interpretation of a statute. A statute is a law that's passed by Congress, and then the Obama administration created an interpretation of that. Okay, so in the Affordable Care Act, there is a section of the Affordable Care Act that people, for shorthand, call Section 1557, as Michael just said in the chat box. Section 1557 is a law passed by Congress, part of the Affordable Care Act. It says no discrimination for a whole bunch of reasons, including sex. Does it say sexual orientation? No. Does it say gender identity? No. You can see where this is going. So the Obama administration said, hey, you know what? Just like I was saying earlier, all these courts that have been interpreting sex really broadly for 20 years to include gender identity and sexual orientation, we're going to put out a regulation that tells healthcare providers, you know what? That seems like a pretty darn good interpretation of the word sex, and you need to follow this as well. So healthcare providers, insurance companies, most healthcare providers, most insurance companies are covered by Section 1557. And under that regulation, it was just told to them super explicitly that they can't discriminate because of gender identity or sexual orientation. Now, our current administration doesn't like those regulations, and so they've been going through the process of rescinding or taking back or nullifying or taking away those regulations. And, you know, this isn't the first time we've seen it, and there are more coming. Well, what we really need to remember here is that that regulation is not the law that Congress passed. The law that Congress passed that prohibits sex discrimination is still in place, still in force, still valid. And what Bostock tells us is, you know what, it is pretty darn likely that the Supreme Court in the next couple of years, or maybe even sooner, is going to hear a case about the Affordable Care Act and 1557 and the discrimination prohibition based on sex, and they're going to be presented with the exact same question that the Bostock cases just presented. Does sex include gender identity and sexual orientation in the context of healthcare discrimination? So, can I answer that question for you today? No, I can't tell you whether sex means gender identity and sexual orientation definitively in the context of healthcare. But what I can tell you is that the Bostock decision makes it tremendously more likely that the Supreme Court is going to interpret non-discrimination provisions in all kinds of other laws in the very same way. So Bostock is going to be used presumably over the course of many years to clarify that we have non-discrimination protections in a whole ton of other laws, probably including the Affordable Care Act, probably including the Fair Housing Act, probably including Title IX, which keeps kids in schools protected from discrimination. It applies to primary schools, secondary schools. It applies to colleges and universities. It's very likely that all of these laws will very soon be interpreted in the same way that Title VII. I see the question in the chat box about religiously focused healthcare organizations. So that's another nuance, right? That adds another sort of complicating fact into the question. So can a healthcare organization that is run by a church, and we know that there are plenty of hospitals and other healthcare systems now being run by organizations that are affiliated with churches. That's one issue. Another issue we have is providers who work for healthcare providers that may not be directly run by a religious organization, but that healthcare provider themselves says, I have a religious objection to fill in the blank. Generally, what we're talking about here are reproductive health issues. Birth control pills, prescribing birth control pills, morning after pills, abortion access, and we also know that it happens with regard to gender affirming care. So we certainly have had plenty of cases across the country where a provider says, essentially, it's against my religion to provide you with medically necessary care. Whether that's hormone therapy, whether that's somebody who needs a hysterectomy for gender affirming purposes. So these are two separate issues, and I would say that the law is not clear on either of these right now. I will also say that this is not my area of expertise. And so I'm certainly open to hearing what other folks think about this, and would love to hear what other folks think about this who read about these things as well. I think that we're setting up a battle here between a couple of different laws. If we look right now at the issue of individual providers who decline to provide services, whether they're pharmacists or doctors, we have a little bit of a problem right now because our current presidential administration issued a regulation about a year and a half ago that sometimes gets called the conscience rule, and that regulation, again, not an act of Congress, but a regulation by the administration, essentially gives permission to providers to refuse services based on their religious beliefs in particular areas. And two of the really big areas are reproductive health and gender affirming care. Now, that law was immediately challenged, and the law was immediately found to be unconstitutional and unlawful by a lower federal court. That case is wending its way up through the court appeals procedures, and it's sitting at an intermediate federal court right now. So this question about whether medical providers, healthcare providers in particular, can discriminate based on religious reasons is broader than just this sex discrimination question. It also involves this issue of this conscience rule, and what the courts are going to do with that. So I think what we need to see is the conscience rule get knocked out, and be found unconstitutional, and then we need an opinion from some courts, some intermediate appellate courts, and eventually the Supreme Court that says, yep, 1557, the Affordable Care Act, we're going to interpret sex discrimination in the exact same way we did in employment law with Title VII, and we're going to include gender identity and sexual orientation. And if that gets done, case closed. There should be no religious discrimination from providers who are covered by the Affordable Care Act, which is most providers. Anybody else have any thoughts about that? I'd certainly be curious to hear others' thoughts.
And this is Michael. I just, I'm aware of our time as well. So if folks have thoughts about it, that's great. And if folks have other questions, I know that Shelley, I can say this for sure, that Shelley will be happy to answer them by email or, connect with you in another way. So
absolutely.
Ask them in the chat, or Shelley, I'm going to type in your email address.
Yeah, thank you. That'd be great.
You can send questions directly to Shelley if you'd like.
Absolutely. Yeah, so I see a sort of comment / question from Heather talking about asking the question, no legal discrimination, right? There's such a thing as illegal discrimination. And I think I understand that question, or I have an interpretation of that question, and which I'll try to address. And I see that we have a hand up, I think, from Marky as well. And so want to give Marky time to ask a question. But yeah, what I would say in response to that, Heather, is that, discrimination happens all the time. In benign ways and in ways that are illegal. Every time we make a decision, we are discriminating, right? When we make a choice. If I choose a purple crayon over an orange crayon, I'm discriminating in favor of the purple crayon. Discrimination in a lot of ways really just means making a decision. So there's all kinds of discrimination that happens every day. Some of it's not bad. Some of it is bad, and a smaller percentage of that ends up being illegal. You're absolutely right.
1 minute of folks' time.
Marky,
Shelley, thank you for doing a really smashingly good job, like always. Really dense material. So I'm glad that we've recorded and people can re-listen to the pieces that are complicated. So thank you, Shelley, for creating a wonderful kind of whole experience for folks. Shelley, do you want to wrap us up with anything that you have learned, appreciated, closing thoughts you want to share with everybody, and then we'll all go have dinner?
I appreciated, the questions that people asked in the comments, and where, where there is still a kind of question or confusion, and, particularly around the interaction with what we're seeing in this increase of religious exemptions around discrimination. And, that might be something that's worth us spending a little time talking about in the future. So I'll certainly be thinking about that. So thank you, everyone.
Perfect. Good deal. Thanks everybody for sticking with us for 8 minutes more. Enjoy the rest of your evening. And thank you again, Shelley, for being really well prepared and sharing so much today.
Great. Thanks all of you.
Good night, everybody.